talking about compliance, and as soon as it was announced, this room quickly emptied out. I will say, this is one of the most important panels. Mind-numbing as it is, there's a certain level of deference that we need to have on this, and we certainly need to understand what the new rules are going to look like. So one request to the folks that are escaped the panel and are chatting out there, if you guys could keep it a little lower so everyone can hear, that would be great. My name again is Rohit Kapuria. I have the pleasure of being joined by several of my colleagues. And what I would like to do on this panel before we get started is just give everyone the opportunity to give a quick introduction, and then we'll get into this very, very important topic of compliance and regulations. So we'll start now with Mike Xenick.
Thank you, Rohit. My name is Mike Xenick, CEO and President of Invest America. We are a broker-dealer affiliated firm. Our broker-dealer is called Sequence Financial Specialist, based in Charleston, South Carolina. I'm based in Tampa. I've been doing EB-5 work since 2010. Have Invest America since 2012. We've represented over 600 investors and their families over the years, representing a variety of projects and lots of different asset classes all over the country. So we're focused on compliance. We're focused on due diligence. We're focused on high quality projects that we can feel comfortable with we are promoting to investors. And we look forward to talking about compliance today.
Vassili.
Good evening, good day, everybody. My name is Vassili Touline. I'm one of the founders of Texo Capital. We are a boutique regional center located in Cleveland, Ohio. The company was formed in 2015, and we got our license in 2017, and we've been active in multiple jurisdictions. Collectively, our team has experience working with EB-5 since about 2010. We have operational and legal and development experience. That's what I feel makes us unique, because we can source the right deals, structure the deals, and we have those expertise and properly operate and be compliant. And thank you, Rohit, for inviting me over to the most fun panel in this whole conference, and we can see that a lot of people are very interested in it.
It doesn't matter, because at the end, even if they don't like the topic, they still have to deal with it. 956Gs are due on December 29th, everybody. So
and thank you, Rohit, for always reminding us about that, and we appreciate that.
Jim Long.
Hello, my name is Jim Long. I'm the general partner of Counsel, the issuer of the EB-5 project. So I just need to follow the rules and share what I understand.
And last but not the least, Jill Jones, who is my favorite person in EB-5.
Thank you for that. And Rohit is my favorite attorney in EB-5 as well. So I'm happy to bookend this panel that way. But my name is Jill Jones. I'm general counsel for JTC Americas. Don't worry if you remember me as NES, I still answer to that. It's just a merger. We're all still here. But we've been involved in EB-5 since 2009, 2010. We've seen a lot of change over the years, and compliance has been the forefront of all of those changes. So I'm pleased to be here for the next phase.
Okay. All right. So we'll start. There are a lot of different things that we have to talk about with compliance, regulation. It's a very broad topic where we thought we would just sort of get into, and again, just cracking some of the initial elements. We will follow along with what's been discussed over time, but I want to talk real quick, just onshore marketing, offshore marketing. So we've got several different facets to how this works. Everybody's familiar with Reg D and Reg S. What people are not necessarily as clear on is how exactly that's going to work within the boundaries of the RIA. So with that, when we come into, just as I would like to throw that over to Mike in general. We had fund managers in the old days, pre-RIA, basically say, look, we are doing one offering, it's not very large, and we're going to do everything offshore. It's all a Reg S offering. Has that really changed now with the RIA?
Well, it depends on who you ask. So for me, it hasn't changed. We've been having to deal with that issue as a broker-dealer, which is very challenging because it's very easy technically to bust the Reg S exemption. You can say you're marketing everything offshore and everything's happening offshore, but when does that threshold get broken? So from my perspective, whether it's the RIA or not the RIA, I deal with the SEC and FINRA, which hasn't changed their position on this. So it's for us, we like to err on the side of conservatism and make sure that even the Reg S investors that we're running through our platform are sort of living up to Reg D standards, meaning that they're accredited. And that also, is almost a common sense thing, right? They're investing $800,000. They're paying an administrative fee of up to $70,000 or $80,000. They're spending legal fees. So they're in this thing for $900,000 to $1 million. So if they're not accredited by our definition of accredited, then they're really not suitable for the investment. So as a broker dealer, it's a very big challenge for us to say, oh, somebody's a Reg S investor, so we don't have to show that they're accredited. FINRA won't buy that argument, at least for us, when it and the projects that we represent when they come and audit our broker dealer.
So Vassili, contrary to what a certain individual who's not in this room has indicated, this is a security interest, black and white. You are selling the limited partnership interest, limited liability company membership interest. You're selling a security. So Vassili, as an issuer, when we're looking at fees and some of the disclosures, and we've had this discussion over time, the RIA requires, and this is separate from the 956K form. So let's just stick with what the disclosures are and who's getting paid. But on the 956F, we need to disclose what people are getting paid. Now, there is an open question because as you're starting the deal, you don't really know what brokers you're going to work with necessarily. Mike's not yet at the table. And you know that you're getting some admin fees, but how are you preparing that and what are you putting in your offering package? Or what am I putting in your offering package that basically?
I was want to what are you actually putting in our offering package? But as the previous panel has covered, the fee disclosure has been a hot topic for everybody in the industry, including us. I personally had, I'm on calls pretty much every day with a lot of agents, larger agents and mid-sized agents in those jurisdictions that I specifically oversee in my company. And I'm educating them and trying to calm them down because they were very worried about disclosures, that their investors would know how much they're making. Because in the past, and the previous panel touched on that topic, they were getting paid from us, obviously, but they were also, the investors didn't know necessarily they were getting paid, and how much. And they were charging on top of other fees, like for documents, a review and some other things. Sometimes I felt like unnecessary work, but it's their business. They never touched it. Our goal is to get the right candidate and be happy with it, screen it. But that's been a very challenging topic. And I think what's going to happen, those who are very active, large, professional brokers and agents, they're going to adapt to it and just will find a way how to properly deliver the message, to their investors that are help us sourcing. Those who are murky, as the previous panel said, I think those guys are going to go away because it's becoming pretty transparent.
So interesting. What I've personally noticed, the India market has settled on the disclosures. This has been out there, perhaps because some broker dealers were already in the business and really helped shape the market. But Jim, if we go directly into your market space and what you've seen, you've got a complicated structure on the NCE side and exactly how the funds flow through the GP. But what challenges have you faced with these brokers over time, with the disclosure forms and whether or not they're actually giving the kickback as Vassili's experienced?
For the sourcing agents, it depends on the market. Also depends on the sophistication and the understanding of the security and also the English level. As you probably know, most Chinese people, they can read a little bit English, but it's almost impossible to comprehend the 500-page writing from the attorney like Rohit. So for them, they trust the agent.
Very nice.
So trust the agent. So agent basically had to push back. They want to write it as vague as possible. So make it very difficult to understand. But with the attorneys running and everybody, they want to make it clear. So there's a big conflict. They have to negotiate with them a lot. Eventually, what the agent does, they put a bunch of execution package, all the things put together, then the investor just sign. Most Chinese people don't ask any a lot of questions. But for the investors or agents from Hong Kong, from Taiwan, from Korea, they're more sophisticated. They understand. So they have more pushbacks. Also, it forces the agents to offer more in terms of more concession, in terms of preferred return and other things. So that's what we are facing. For our direct investor, so we do source directly with pre-existing relationship in the US. That's what lawyer asked me to do. So we keep it open. We also offer them little bit more incentive to sign with us. That's our experience. But it's a challenge, especially for the English-speaking countries.
So this entire conference, as a reminder, is being live streamed. So to the extent a USCIS adjudicator is actually listening and watching, I would like them to know that everybody here is fully 100% compliant with the law and with the RIA. So with that, Jill, as a fund administrator, and we'll talk a little bit more just about what fund admin does over time. Your role is slightly different. You're coming in as a core Sherpa, and you're working directly with the NCE manager or general partner. What is your view when you're looking at these disclosure packages? What are you looking for prior to you even getting involved and or releasing any funds to the extent you're on the escrow side as well?
Thanks, Rohit. That's a great question. As a fund administrator, there are a number of things that we're concerned about in the disclosure section. Primarily the things that we're touching, the things that we're involved in. Prior to the RIA, we didn't have to be involved in dispersing funds. Now it's very clear that we do. And so what we're looking for is how clear is it what the triggers are to release funds and what the documents will be provided to justify such a release. So we're looking very closely at what are the documents describing, what are the list of additional supporting documents that will be provided, and do we understand and follow that these documents are saying the same things? It's unfortunately very common that we'll look through different parts of the offering package and see conflicts in that very category. And so we spend a lot of time making them cohesive.
Aaron?
Sorry, a question before this topic. Right, so the
Microphone.
thanks to
Yep.
Thanks to you and Ronnie and the lawyers we're working with. Obviously, we have a lot of kind of additional disclosures, additional comments or sections in our offering documents and service agreements with these promoters, etc. And these are very kind of heavy on the promoters as well. So, and we're trying to be compliant. Do you think we're getting penalized by being diligent and trying to be compliant? Because some of the other regional centers or other issuers who are not working with diligent attorneys like you have much lighter documents and much lighter service agreements, etc., which the promoters are kind of diverting to. So, what are your thoughts about the kind of this conflict here? Like, is the compliant one being penalized in this new world?
I'd like to take that one if I can.
Please.
No, I don't think you're being penalized. I think being held to a higher standard up front is probably a good thing. The lighter packages haven't been filed with CIS yet. The petitions that follow those packages haven't been adjudicated yet. I think they will have many RFEs just for that very reason. I think being diligent up front makes your offering solid and it makes it have less impact down the road requiring changes or additional things to be added after the fact. From an investor perspective, I think it offers a sense of security. They can see what the offering is and how it's going to remain the same throughout the offering.
So let me play devil's advocate on that particular point, and I 100% agree with what Jill says, but one of the comes back from those folks that are filing with the lighter package, they say, well, USCIS itself doesn't really know what it wants under the RIA. The 956K itself is not fully published. And Ayla, with the help of Ron Klasko, actually prepared some questions and feedback that went to USCIS to say, hey, these are certain clarifications that we want. But with that being said, if the agency itself is not 100% clear, then on that level, who's leading? Should it be the more compliant, which we all believe on this panel is the case? Or will the guy who's going with the lighter package actually help USCIS kind of form that this is where maybe the industry could then go? Back to you, Joe.
Well, I certainly hope it doesn't form USCIS's vision of how it should go. I think that's dangerous. I think it leaves everything open to interpretations. And from where we sit today, there's too much already open for interpretation. We want to close it. We want certainty.
So, you know, what's interesting on that level, I'm going to throw this over to Mike, is we've noticed over time that SEC and USCIS are working hand in hand. Some of the language that we've seen in the RIA is very similar. It's what you would expect in a normal broker-dealer side. And so, Mike, based on your experience, when you're looking at these disclosures, these are things that you've normally had to do. You've had to provide all of these disclosures to investors. You had them, you actually sign the documents. You didn't bury it in a bunch of signature pages. You actually made them read it to the extent you could. What is your experience just looking at the law vis-a-vis what you've had to do on a compliance side with FINRA over the years? Do you see similarities? Do you see differences? What do you?
I see a lot of similarities. You know, I think and I'd say it's probably even a little more detailed, a little more transparent than you can have an investor sign something, and I've seen, depending on the regional center, they've had, you know, some very, very specific about the exact specific fees down to the penny, or they say up to something. So that's one thing that's a little difficult to deal with on our side, because there's no consistency from regional center to regional center on how those things are worded. But as it relates to, you know, the substance of it, I think it's very, I was actually pleased to see what a lot of regional centers are doing to make that more transparent. If I can also just follow up a little bit from the investor's perspective on the last, you know, comment related to documents that are more compliant than others potentially. If investors don't know what they should be looking for, they're not going to know that they should be going with this one because it's less RFEs. And when we talk to people, we talk to attorneys, or we talk to the investors themselves, we have to really hammer that point, because if we don't, they're not going to, they don't see the difference between one project to the next as it relates to that specific aspect. And I think that's going to be bad for them down the road, but they don't know that yet. You know, they don't, and then obviously there's some investors are more sophisticated than others, and they're going to figure that out on their own when they do their research. But just, especially if they're being directed by an agent who, again, maybe diverting to the lighter documents, they're not going to know. And I think that's one of the big challenges in the early stages of the implementation of the RIA for this specific aspect. That's going to really, I think, come back to bite investors, and they're really not going to know, you know, what's happening to them until it happens.
Okay, so that kind of leads into the to be published 956K form. Vassili and or Jim, have either of you had any questions from quote promoters, which is an open question, what is a promoter, offshore, as to how exactly they're going to fill out these 956Ks and where they're going to do biometrics?
I communicate the draft copy to all of my contacts in the agency. All of them express desire to file, but they are always asking for recommendation for the alternatives. I said, I'm not the one to answer your question.
So you
better
know,
ask about everybody else though. But they all waiting to do it. Actually, I had a communication with the Worldway just minutes ago. They are ask them when I can file, okay, they're happy to do it. So they just don't know whether they can provide all the information they need. They also don't know what's the other sort of liability or risk.
Well, I mean, and then the question also becomes, how far up the food chain are we going? Are we going to the main shareholder who's signing? Are we going up to the holding company? Are we going up to the parent company? It's an open question.
That's a very good question, especially for agency in China, in Vietnam. They all have offshore entity in Hong Kong, Cayman Island, or some weird country. That's the company receiving money and going to do registration. Actual office working is in Shenzhen, Shanghai, or Ho Chi Minh City. And I don't know how to handle that, okay? Right now, I just follow the paper, as soon as they do it, I pay legally and with lawyer's blessing, I'm happy.
The lawyer's blessing may be good, and you take that with you. Okay, so Vassili, on just kind of moving from that, because again, we don't really know where that's going to go. Let's talk about certifications that a regional center has to make. So everybody in this room by now should be familiar with the fact that before a project actually goes to market and before you can actually bring any investors into the deal, a regional center that is sponsoring a particular project has to file a form I-956F, as in Frank. And that particular package is filed by the regional center. Within that context, the regional center, which may or may not be directly involved, either through an affiliate or not, has to make a number of representations to USCIS, that it's actually reviewed the security interests, it's reviewed the project, it's read the business plan. I mean, a host of different things that are actually outlined within the RIA. Vassili, as a regional center, you've sponsored projects that are yours and some projects that are not yours. Has your market and your intent changed with the issuance of the RIA?
Well, my intent and my approach has not changed because we've been very diligent in reviewing and sponsoring deals. So we were, I'm an attorney myself, so I've always been, I guess, reviewing it with extra diligence, maybe than, I don't know, someone else. I know how it works, what legal risks are present, and my approach has not changed with this. However, I do understand that with this certification, it adds an extra layer of, legal risk to me and my team. So clearly, with respect to our, our own deals that we're sponsoring, again, I don't have any concerns as of right now. But moving forward, for example, if someone approaches me and say, I'd like to use your regional center, could you sponsor my, can I like rent your center or something like that? And someone actually approached me the other day and I said, well, the short answer is no at this time. I'm not ready to do that because, we're still figuring out the landscape and we haven't done it. We only did make one deal where we, kind of called rent the center, but it was a small deal and we were not worried about it and we had our due diligence done. But I understand the legal risks are high right now. So that's for sure.
Well, I mean, and to be clear, this model, the quote rent a center model, it's not necessarily a bad one, right? And it's not a bad one, as long as the group that's actually running it has a tight shop and has a lot of compliance in-house. So some of our members in this audience, folks that we work with on a regular basis, clients, they do quote sponsor other projects that they're not affiliated with, and they provide a level of oversight, and they come in with a third eye, if you will, in order to ensure that the project is compliant. But the certifications that are there are immense. And one thing the marketplace has to get used to is the cost factor. It is a lot more expensive for a regional center, not just because of the annual filing fees, but also because of the level of diligence and the legal risk and the liability Vassili mentioned they have to take. Jill, as a fund administrator on that same bullet point, talking about certifications, you and I spent a lot of time on one of the first few 956Fs that were being filed with regard to how JTC would, fill out the actual form 956H as in Henry. And there was questions as to whether we needed to go JTC level, whether we needed to go below that and actually get into the individuals. Has your position changed over time, or have you received a biometrics appointment at this point?
So no, I've not received a biometrics appointment yet, but you're right. Filling out the form for JTC is a bit complicated, but in a good way. So JTC USA Holdings is our US parent company. JTC USA Holdings is formerly NES Financial. We've been a fund administrator for the last 12 years. So we have a subsidiary we operate through, NESF Fund Services Corp. That houses all of the employees that have been doing fund administration, specifically in EB-5 all this time. So they have requisite experience. Problem is, in the United States, there isn't a registration or a license for a fund administrator. So if we just fill out the form, say NESF Fund Services Corp, that leaves a gap. Some folks have used our employee ID number, our tax ID number, and filled it in that way. But if you go back up a level, JTC USA Holdings also owns an RIA, Sally Fund Services. That entity has a registration number. Some folks have said JTC USA Holdings with Sally as the RIA and with NESF Fund Services as the fund administrator. You could even go further than that. Underneath JTC USA Holdings, we have attorneys, myself included. You could use my bar number if that's the way you wanted to go. Either way, everything funnels into the same parent. Now, whether USCIS wants to see how detailed you want to go. Ultimately, we're satisfied that we cover it from every different angle possible. So that's where we sit today.
You know, interesting on that level, when you get into the org chart, which if anyone's ever picked up a PPM that we've ever prepared, we always include one. And we noticed that USCIS looks at that very carefully. They want to understand who all the players are. One of the earlier 956s that we had filed, this is before, you know, as over time, we various experts in the industry like Ron and, you know, trying to understand what other folks are actually doing, we morphed in terms of what we believe USCIS wants. We got an RFP recently on a 956 where we showed who the main players were, and the actual ownership was just sitting at a holding company level in, you know, an LLC. We disclosed that. We actually also disclosed that as part of the operating agreement, it's the same individuals for which we provided the 956Hs. The RFP was very simple, but it said, we want a 956H on the companies. Like, okay, well, here you go. It's signed by the same person, but they still wanted that. So it's an open question. I think even just the adjudicators are trying to start, you know, deal with. If it's all held by the one person or one controlling member, then that should be sufficient because that's the person that's actually going to sign the checks and do everything there. But Jill, I mean, on your level, are you saying that it's a standard practice that you go as high as, you know, all the various levels, or are you simply just leaving it at JTC US?
Well, it's not really up to me. I don't fill them out. We provide the full org chart to each of our clients and we let them choose based on consultation with their attorneys, how detailed they want to go.
Okay, easy. Mike, what about you? When you're making any certifications, what are you doing?
We're at the BD level, and you know that's kind of where we stop.
You stop right at sequence?
We stop right at sequence.
You don't go down to the individuals?
No, as of now, no.
Okay, all right. I think then, you know, as we're more, this is again, it's clearly an open question. There are different practices around the area. Various 956Fs have been filed. It's also clear from the stakeholder call that USCIS itself is not 100% clear on what their practice is. If anyone listened to the last stakeholder call, there were a lot of presentations by the various members of the IPO. It was very helpful to hear and actually see the faces of some of the individuals and get the names. But beyond that, we know that this is an evolving situation. I want to move next to the policies and procedures manual. Again, a very complicated document, but one that you know, we at Saul Ewing had spent a lot of time on initially when we were starting to work on the 956s. We know at the 956 level, F level as well, it's a very important document. We know that USCIS has been reading these carefully. We have seen an RFP that was issued to, someone in the industry as well, where USDA has paid attention to the actual policies and procedures level. And they went directly into the document to say, well, prove to us that the individuals working at the issuer entity are not getting transactional based compensation. So no extra bonuses on the basis of securing an investor, which basically means we're getting into the employment agreements and now have to understand what exactly the adjudicators are thinking. So they're thinking with an SEC cap on, but it's not very straight because the questions were not very clear as to what they were seeking. So I'm going to throw this question over to Jim Long. Policies and procedures manual that you've seen, you're not directly a regional center, but when you're looking at the 956F, what are you seeking within that form, within that document, whether it's 20 pages, 30, 40, 50 pages, whatever that is?
I don't really know how to answer that question.
I just stumped.
I read through, I sort of make sure I feel my side of responsibility in terms of transparency, communication to the regional center. And also for the menu itself, I think our regional center also received RIA, needs to refine it as well. So they do check it very carefully. So you follow the guideline and we provide a monthly report to the UCD regional center. I have a regular meeting with the regional center to make sure they know exactly what they're doing.
It's not a form document. I mean, Jill, on your side, do you read that as a fund administrator? Are you concerned about any representations that we made in there vis-a-vis what a fund administrator does?
Absolutely. If it's representation for my duties, I want to read it very carefully.
And broker dealer side, have you read one of these?
I read a couple. Some have been really good, and some not so much. And for us, we obviously this is something that we have as a broker dealer. It's a requirement, part of our written supervisory procedures that every broker dealer is supposed to have. And so we probably look at it with a much more discerning eye than most people. It's always been part of our due diligence process when we're representing or looking to represent a regional center and their projects. So it is it's not anything new to us, but now we know that we've got to spend a little more time on it.
So when you said that you've looked at some and some are not as good as others, what exactly are you pinpointing there?
I think the ones that we've looked at that aren't so good are ones that they've just very minimally checked the boxes, where they say, okay, the RIA says this, there's no real guidance on it, of what it's supposed to look like. So we're just going to make sure that we have some stuff that covers those things. So, and that maybe that's too much of an exaggeration. They demonstrate what policies and procedures they have, but then you get to a regional center that is like a 1 or 2 person show, and it's hard to have policies and procedures when there's a couple of people, there's no significant back office, there's no people involved, and that's where we can help. We can provide them with some guidance on that, and also where we can based on what we do, we can add scope of services, what we're doing to complement what they've done and show that, okay, we're doing a lot of this back office work for them. We obviously charge a fee for that, but that takes at least some of the burden off of them to show that policy and procedures are being done through the broker dealer as they're going through their fundraising.
So, that raises a question again, when we're going pre-RIA and post-RIA, is there were certain models, right? There were templated forms, if you will, on what a regional center sponsorship agreement would look like. There were, it's an element of here's 10 pages of various jargon with legalese, if you will, and then here's a 1-page addendum that talks about the fees that are being paid to the regional center. So that model is not necessarily what we should be going to anymore, right? We should basically throw that out. And the regional center, with its certifications that it has to make to completeness, to the security interest, to the accuracy of what's in the underlying documentation, that becomes very important. So when you get into a situation where the regional center is completely unaffiliated with the issuer, unaffiliated with the developer, it has no oversight on a day-to-day basis, no management authority, that policies and procedures manual becomes extremely important. That's what's going to govern at the end of the day, how the regional center is basically going to watch over and supervise this issuance of a security interest. I say it again, and not as a joke, but this is a security interest, no matter what folks in the industry have said. And so we do need to take that, to heart. So from a fund administration level, I think, Jill, when you're looking at projects, looking at making a level of certifications and accuracy, I want to talk about record keeping. Another very important element, which JTC does very well, from an 829 perspective, keeping all that data. So moving from pre-RIA, where if you were retained to do EB-5 compliance and you were keeping records of escrow funds and the trail and how it basically went downstream, have you changed your model in terms of record keeping, depending on what services the issuer has availed of you? If you're just a fund administrator or if you're the escrow administrator as well.
So I break that down into two buckets. There's the record keeping on the money side, and there's the record keeping on the immigration and project side. And those two differently in the past, I think they're merging more to be the same today. Meaning we have always kept records of audit trails, every dollar in, every dollar out, who was the beneficiary. And we post those reports into a portal. And our regional center clients, our NCE clients, they can log into this portal and pull those reports out. What's been highly overlooked until recently is that there's also an access for an investor to see their individual slice of the pie. That now becomes required to be provided to the investors. So that tool that's been available all this time has now become far more important. And using this tool to not only post, here's how your money was spent, but also here are the sections of the regional center audit that need to be shown to you. Here are the aspects of progress on the project development that need to be provided to you. And not just right now, but for a 5-year window after the fact. It's not like people have been prepared until recently to keep records for that duration of time and make them available to not only the investors, not only the issuers, but to USCIS should they come asking.
So Jim, you're working with Jill. You are a general partner on a fund. She's your fund administrator. To the partnership, investor has funded, let's say, 2 tranches of capital directly into the NC account that's overseen by both the fund administrator and the GP. If you want access to it, you've got your guidance on the escrow document that tells you exactly when the money can get released after several different triggers have been met.
Right.
But what additional platform are you providing to the investors, or how do you communicate with Jill just to say, look, here is the evidence, or is there an extra step you're having to take outside of just the escrow release triggers?
First of all, we always provide the link to re-emphasize they have online access to those records. The investor can log on themselves. I also, myself and the LCR client service, IOTA, also send an email with the confirmation letter to the investor and the agent direct. And also when the all execution package comes back together, we do a review, we send to the immigration attorney. That's the process. Then on a regular basis, every 6 months, we send the preferred return statement, ask for address update, bank info update, and also at the beginning of the year, we send the K1 to individual investor, asking whether they would like to have a audited financial report. So we all provide those things to keep them informed. Yeah.
So you mentioned audited financials. I want to take that and segue back into fund administration for a second. So previous panels have kind of talked about this, but I want to bring this up because it's a really important topic. One thing that we have, and Jill, I'm going to throw an economics question at you on this. One thing that we have a lot of times when we're talking with different projects is what is the cost of this fund administration service versus if we were to do an audit? How exactly does that play out? We've had various different clients wanting to take different approaches to this. There is an open question as to whether or not an audit is going to sit just at the NCE level whether it's actually going to trickle downstream into the JCE. We know certainly if there's an affiliation, it does trickle. There's an open question though, based on how it's written, different people have different interpretations. If we're going to be extremely conservative, we would say you would need to do an audit of the NCE and the JCE. And there's obviously a cost factor. And most JCEs, it's not really a big deal because they're already doing the audit. So if you're a developer worth, your salt and you've had a lot of experience just within the development world, real estate world, you're already doing annual audits. Jill, as a fund administrator, does this give you a lot of agita in terms of what you're saying and what you're presenting to the clients, why they should pick one over the other?
Sure, I think ultimately it comes down to, we're not comparing apples to apples here. If you are trying to choose between having a fund administrator or doing an audit, I think that you may be having the wrong priorities. It doesn't come down to money, it's going to be a look backwards. Anything negative that may have happened already happened and there's nothing you can do about it. Fund administration is real time, up to date, what is going on, and hands-on interaction. So if you're trying to decide which is a better fit for your model, that would be my answer. However, my caveat to that is please come back after lunch because I have a panelist, David Appel, who has some strong opinions about the cost of the audits on the NCE and the JCE. So I'm going to leave you with a cliffhanger there.
With that cliffhanger, we have 5 more minutes to just bear with us. Really interesting topic, right? Yeah, ladies and gentlemen? No? Oh, thank you. Yeah, thank you, Brennan.
Very
So, yeah, exactly, right? Compliance regulation. Vassili, on this level, right? So just going again, keeping in line with audit versus, fund administration, you and I had discussions about this. And so what have you perceived with investors, right? So twofold question. Number one, as a regional center, do you have a preference? And number two, what have you perceived the investor pool wanting of you as you're actually discussing projects with them?
Well, we prefer fund administration and some visibility, and for us and investors, access has been discussed. So we like that. Audit definitely comes into play. But again, to Jill's point, I agree with her. It's really could be 2 different things. Depends on what the regional center is looking for. But we lean towards fund administration model. For us. What was the other question? Okay.
From a regional center standpoint.
Yeah,
That's regional. And then investors, what are investors asking you?
well, and we've always been very transparent with our investors. They've always had exposure and access to whatever documents and financial information. So they're always looking for transparency. I rarely saw an investor that would be comfortable not knowing what's going on. I actually happened to meet a couple of people that filed with. They're like, "Well, I haven't heard from my regional center in about a year and a half. So, what's going on? Any suggestions?" Like, well, you should contact those guys and ask what's going on. But again, we're about transparency and we're always communicating with our investors and keep them in the loop of what's going on with their project, with their funds, and those forms that Jim just mentioned, K1s and all this stuff. We keep sending and getting updates.
We use both fund administrator of JTC. We also use Baker Tilly to do auditing because we need to generate the K1. I mean, our accountant doesn't want to generate like 160 K1 by himself. It's better to use a professional service. But if Baker Tilly wants to do K1, they want to make sure the financials is audited. So it's a natural sort of a thing. Then we
Tom
have
Martin's
good
in the
record.
room. He can do all your audits right there.
I know you don't, but it's your,
But Baker Tilly's happy to do your.
it's your print office, that's what, okay.
So with a few more minutes, I think, Mike, I want to talk about what it means to have a broker dealer involved in your deal. So just pretend I don't know how this works. Pretend I am a new issuer coming to EB-5. There are a few folks in this room who've never done an EB-5 deal before. And they understand fund administration from Jill. They know they have to go talk to her about how that's going to work. What does a BD bring? Now, let's not talk about just the overarching principle of it. How does it actually work procedurally if you sign on to the deal And what does it mean in terms of marketing? How does that procedure really work?
How long do we need? Well, basically it works like this. If you're interested in, because we basically do two things. We make sure as a broker dealer that the entire offering is being solicited in a securities compliant manner. So that's sort of the overarching thing that we do. And we also can market and find investors. So on the compliance side, and we have a variety of scope of services that people can choose from, depending again on how sophisticated their back office is. But we can, if somebody comes to us, we're going to initially do a very intense due diligence process, as some of our clients in this room can attest to. And that looks at every aspect of the offering, all the legal reviews, agreement reviews, all those kinds of things. It's very intense.
You're amending documents too, or you're suggesting amendments to documents too, correct?
Correct, yeah. If we see something, well, depending on, if the offering is already on the market, sometimes we'll get something where we're just a sub-agent, so to speak. There's not a whole lot you can do about a PPM that's already out there. And that may be depending on how much of a deficiency there is, that may determine that we're just not going to.
Pointing at me, man, our PPMs are fantastic.
Wait, I wasn't talking about you. I wasn't talking about you. But we will recommend, changes to documents, whether it's particularly in the PPM, particularly related to risk disclosures, particularly related to, is there consistency between the PPM and the business plan? So we'll definitely do that. Once we're satisfied the due diligence we're going to have done the due diligence and we're satisfied it's a good transaction that we're interested in representing, we'll also, in the meantime, we'll also show it to our network. We've got several registered reps with us that are registered with the broker dealer that are focused on different markets. One person focused on India and the Middle East. We have a couple of people focused on South America and Brazil. And then, is this going to be marketable? Can we sell this into the markets that we're focused on? And if all that happens, then we sign an engagement agreement that basically says we are going to provide these services. That includes evaluate each and every investor that comes in. We're doing OFAC checks. We're doing a investor questionnaire. And as I mentioned before, whether it's Reg S or Reg D, we are doing accreditation assessments for everybody that comes in, mainly for suitability, mainly to satisfy regulation BI, best interest, which is a new regulation that FINRA introduced a couple of years ago. So we're doing all that as the investors are coming in. We're providing them the opportunity to do due diligence on the investment. We are answering their questions. We're introducing them to the issuer. We're making sure that all their questions are answered. We're helping them get through the process. We're holding their hands if they need it to fill out the subscription documents and the related documents. And we're making sure that all that is done properly. We're making sure that, again, they're getting fee disclosures, and we're helping the regional center, again, to the extent they need it, get that investor in the door, signed, working with their immigration attorney also to review source of funds from an anti-money laundering perspective, not necessarily a USCIS perspective. And we've caught some things in the past where an immigration attorney did source of funds, but they didn't do path of funds, where they said, okay, yeah, it was lawfully generated, but we don't know where that money went from, October of 2019 until October of 2022. There are no statements in between. So we have long gap. So those are the kinds of things we do. Marketing wise, I mentioned the markets that we're in, India, Middle East, all of South America, and including Brazil. That's where the history of our firm has been over the last 10 years. And we will do seminars, webinars, all different kinds of things to make that happen.
And that was 4 minutes. He's paid by the minute, I think. So, all right, lightning round. So before we are standing between you guys and lunch, so lightning round, keeping in line with what other folks have done. Key compliance issues that you guys are focused on an individual basis. Keep it to 20 seconds or 25 seconds maximum, starting with Vassili.
Key compliance issues. Well, we're definitely spending more time reading all the documents and just, we're wrapping up a deal, as you know it. So it's been very time consuming and we've been going back and forth. So be prepared to obviously spend a lot of time, you know, in reading, reviewing, structuring the deal, the way it should be. And then obviously, you know, dealing with, on the other hand, because I oversee, you know, the CIS country marketing efforts, you know, I've been educating on a daily basis those agents and partner networks that we're working with how to, you know, approach the new era of EB-5.
It does say it takes a significant amount of time on the new deals. So lots of clients are always in a rush to get to market and file the F. It is a lot more work than it's ever been. It takes a lot more effort, even just to put a 956 F together, but
Yeah, that's been our experience, for sure.
yeah. All right, I'll go back real quick to Mike and then I'll move on to Jeff. Any key compliance?
Consistency of implementation of the new RIA requirements, particularly investor disclosures, transparency, those kinds of things. The industry as a whole, now obviously there's lots of people that have been doing it the right way for a long time, but the industry as a whole, there's really no guidance yet on what USCIS is looking for. So I'd say, you know, there's a risk in not being there being no consistency in those new compliance regulations.
I think, Jim, you're ready for a site visit if USCIS were ever to come, which, by the way, we should all expect site visits pursuant to the terms of the RA. But on your level, is there anything that you're doing differently as an issuer?
Well, I think that our sort of from Hall on myself, the top priority to hire best attorney, run class or running, and work with best team, then keep on record. That's all, okay. And then we have a great project to show, so we're welcome to visit anytime.
I like that.
Dropping names.
Yeah, so Jill Jones, you've got the final word here, if you will, and anything you want to give in terms of key compliance, apart from coming to your session right after this.
Key compliance for me is always going to be disclosures, accurate disclosures, consistency of disclosures, document retention, document disclosure to the appropriate parties, and the availability of accurate data.
All right, with that, thank you, everyone.